First of all, I want to thank the Center for inviting me back again. I spoke at a very effective conference in either 2013 or 2014, and I was stunned by the level of turnout and interest that the student body had here. And I was asked to give a speech at BYU, and so I called them up and said, could we have some kind of a repeat? And I'm very happy to say that we did. I also want to say that one of the ways in which you become, an original and creative mind in constitutional law is not to teach the subject. I have taught constitutional law as a separate course in my life exactly 2 quarters. I spent 1 quarter teaching something on the structural constitution, which for those of you who think of this as somewhat mysterious, means how you put a government together, various houses of Congress, separation of powers, and federalism, and another one on the First Amendment. The rest of the subject is to some extent terra incognita. I regard this as an enormous advantage in doing scholarship in constitutional law, because essentially it ties in with the basic theme of the title of this particular lecture. And the title of the lecture, if I remember it correctly, is A Common Lawyer Looks at Constitutional Law. Now, as I was sitting down at that seat over there, which is now empty, I asked 2 students what they knew about common law, and they told me they knew of common law marriage. And I said, well, that's a start, but you probably need to know a little bit more than that in order for this somewhat familiar and somewhat elusive phrase to make some sense. Am I doing something wrong?
Nope, just get the mic closer.
Oh, yes. Thank you. All right, this somewhat familiar but somewhat elusive phrase, because I think, in effect, it's extremely important that you do it. The legal system that we have has essentially several characteristics. One of them, which is caught by the phrase common law, is it means that this is the general law which is applicable to everybody in the land. And there are many rules which are, of course, specific to particular injuries or particular industries or particular fields, but the common law are the sort of general principles that are said to bind everybody. Second thing about the common law is that the principles that we're talking about are made by judges or even by scholars. So that if you were like me, a person who started his legal studies with Roman law, which is the basis of much common law, you would discover that the judges didn't have much to do with it. Sorry, judge. The stuff was written by a bunch of academics and scholars, and their opinions were then applied in particular cases as a matter of what they called natural law. That is, that body of law which does not relate to any particular sovereign, but is the law which seems to commend itself to a cross between reason on the one hand and custom on the other. Now, the common law is extremely broad and versatile. It covers a wide variety of rights and duties and deals with a huge set of remedies. And so if you are a common lawyer, what you do is you have to develop rules about individual liberty and the reasons you don't have slavery. Then you have to figure out what these free people are entitled to do, how they can acquire property. Taking it is the usual answer, a bit more complicated, but basically right. Then you have to figure out how they can put their property to good use. Then you have to figure out how they can combine their property with the property or labor of other individuals through contracts, buying and selling houses, forming partnerships and the like, even getting married is a kind of contract. And then what you have to do is to make sure that as people put these elaborate systems together by agreement, nobody from the outside can rip them asunder. And that's called either the criminal law or the tort law, depending upon whether it is enforced by the state on the one hand or by private individuals on the other. And the basic norm of the tort law is stunningly simple in ancient times. Keep your hands to yourself is the inexact way of stating it, and do not engage in the threat or use of force against other individuals is in fact the more precise way of putting it. And so what you do as a good common lawyer is you try to develop the reasons and the explanations as to how these systems are put together. I will give you here the 4 or 5 word version of the subject, knowing that it's capable of some expansion. But the reason why our legal systems work as well as it does is the summary that I'm about to give you now is 80% accurate. It's the other 20% that requires those endless volumes of law books that you see scattered throughout this library. And the 5 words are force no, cooperation yes, presumptively. That's the whole speech. I'll repeat it for you so that you can now graduate from law school at the end of your sophomore year. Force no, cooperation yes, right? Presumptively. The first thing essentially says is that the use of force in all of its forms is essentially a destructive kind of activity, because what it does is it creates a system in which nobody can feel secure in their person or property. If you understand that when you're talking about force, you look around the room, you have to be suspicious of everybody. It may well be that there's only one person who wants to harm you, but you can only be killed once. And so what happens is, in a world in which force is allowed, the fact that 99% of the people in the world are well disposed for you means that your life expectancy goes up from 10 days to 2 weeks. It does not protect you. And so the general social contract is to require essential mutual disarmament, and then you have to figure out how to put a state in place in order to enforce it. If you look at cooperation, turns out it's a very different situation. I can't raise my barn, you can't raise your barn. But if I help you in the morning, we can raise mine. If you help me in the afternoon, we can raise yours. Essentially, the central proposition of cooperation, yes, is that there are gains from trade. 2 people put in something, and each of them gets out more than they put in, and then lustful people, energetic people, imaginative people will do this over and over again. And so one of the things I like to tell students when they're starting out is to ask the following question: how many contracts have you made today? And you look at me, sort of weird. What's this guy talking about? You're not quite sure how you count, but if you count everything that you do of a voluntary nature, as I indicated before in the side conversation, somebody lends you a pen and you return it, that is the performance of a contract of bailment, a phrase that you've never heard in your entire lives, right? So what lawyers did originally is what they did is they watched what people did. They were like biologists, and they then cataloged the various kinds of arrangements that they entered into: partnerships, employment, sales, loans, mortgages, and so forth, and developed the rules that governed each of these things. The common element of them all is they tend to create increased benefit for everybody else 2 ways: 1, within the parties, and 2, by giving greater opportunities to other individuals. But law is a science of successive approximation. So we get to our last word. The word is presumptive. And what that means is too much of a good thing is a bad thing. So we want to have a rule which says force no, and then somebody comes up to you and says, well, somebody's now attacking you. You just have to take it and lie down and die. And we say, no, it's presumptive you can't use it, but you can also use it in self-defense, right? Or the defense of a third person. And then what you do is you develop a series of justifications as to how and when force can be used. And what the word ordinarily signifies, what the word presumptively signifies, is that a first approximation is not the final state. But don't despair. How many of you in this room have used force in self-defense in the last 24 hours? The answer is probably virtually nobody under these kinds of circumstances. So then you look at contracts. Generally, they're a good thing. What about a contract to murder a third person? Not so good after all, because the external losses dominate the gains to the parties. So contract freedom is presumptive as well. So that last word that you see in the common law formulation tells you that, to use the ways of the song, you've only just begun when you start off with the first 4 words, and the 5th word is designed to tell you that there's a long journey ahead of you. And what happens is this: in ordinary social interactions, the first 4 words generally do very, very well. And then when something gets screwed up, you go to a lawyer, because they're the ones who are going to have to tell you whether the presumption holds or is overridden and overridden again. Most of what you do in ordinary social life, you understand so well that you don't even know the rules that you follow. And then when something's hard, you have to be able to figure out how you put these rules together. Now, there is a kind of deep irony about the common law that I want to mention. This stuff is judge-made, and generally speaking, in our legal system, we have a three-part hierarchy, which you may as well commit to memory. I see diligent students writing things down, which is why I'm speaking uncharacteristically slow. And the first and the lowest rank is the common law. On top of that, it turns out that there are statutes. And the general rule in our legal system is that the considered judgment of the legislature can modify, improve, or displace the common law rules and put something in their place. And the kinds of statutes that you have can be very complicated and extremely long. Let me just mention two types to you. One, there are what they call codes. Somebody says, oh, we've looked at the commercial practices in sale, and they seem to fall into a certain pattern. Let's just try to codify what everybody seems to have understood. And then there are reform statutes which come along and says, we don't like the way in which the gold industry is organized. We're going to have to change it by legislation. And when you look at these statutes, the rule is statutes trump the common law. But does it? And here let me start to say to you that for somebody like myself who writes in that classical liberal constitution, we start to distinguish very clearly between two kinds of statutes when we start to think about our third layer, which is how the Constitution ties in with this. Because the common Constitution is a common law system, which is higher than a statute, which is higher than a common law. So what happens, you get this peculiar three-part layer. You start at the bottom with common law rules, then you improve them by statute, then you say some of the statutes are unconstitutional because they deviate from the common law rules. This is a little bit dizzying to many people, but in fact it is a fairly accurate description of what goes on. The question is, why does it start to make sense? Well, take the middle layer, dealing with statutes, and see the way in which it is put together. And here, the kinds of statutes that one likes are the statutes which in both Roman law and in early English law were said to basically perfect the common law rules by making them administrable in a world filled with all sorts of uncertainty. So, to give you an example of what uncertainty might look like, everybody agrees that if I promise to sell you my house for $10,000 and you agree to buy it, that sounds like a contract. But there are two serious problems with respect to this kind of an arrangement. One is, after the fact, there may be an enormous agreement, or disagreement rather, over whether or not we really did strike a bargain. I would say it was just a preliminary negotiation. You will say that it's a final arrangement. Each of us will give anecdote and conversation on it, and the whole system will become essentially unsustainable because of the constant factual problems, which will in turn make people reluctant to enter into transactions, because I want to buy or sell a house, I don't want to buy or sell a lawsuit. So what the judges do, what the statutes do, is they create different ways to make these things more certain. So one statute, which is extremely important, is called the Statute of Frauds. It's a very old statute from the 1670s in England, adopted in every state in the United States today. And what it says in its simplest form, presumptively, you know that word now, right, is that certain promises to buy or sell real estate are not enforceable unless they're signed in writing by the party to be charged, i.e. by the potential defendant, the party who sued in a lawsuit. And since you never know whether you're going to be a plaintiff or defendant, in practice, no deal is complete as a contract until both parties have signed it. Now, this is formality. This limits what you can do because you can't create oral contracts anymore. But the argument of the common lawyers is what we're doing here is making both parties better off by instituting a regime of greater certainty with easy formality, but it's not a statute which says you have to pay this much for the house or you can't pay more than that amount of the house. What it is you increase the degree of freedom by increasing the degree of certainty. And so anybody who believes in the common law rules of cooperation, yes, is grateful about these statutes because it increases the scope over which cooperation could take place. One of the things that you will learn about contracts, if you should ever study it, is there are some contracts that call for an immediate exchange. I think many of you have purchased a newspaper. I don't believe that you've ever signed a contract in writing before you did so. That's because the money and the paper change hands essentially simultaneously. Can't do that with real estate. You need to have all sorts of inspections of title, all sorts of inspections of the premises to make it go. And so the legal system develops formalities. It's not just the statute of frauds. You have to find a registration, like a bulletin board, you put it down, so the same person can't sell the same piece of property to 10 different individuals. So the early common law approach was very sympathetic to statutes that increased the security of exchange. And if you start going back to the founding philosophers who are of such interest to the Center of Constitutional Law here and studies, it's guys like Hume and Locke and Madison and so forth, all of whom wrote in one form or another that the security of possession and exchange is one of the fundamental objects associated with the operation of the law. Now, the second kind of statute is in fact somewhat different from that. And what it does, in effect, it says, we see these kinds of common law relationships, but we don't like what we see. And we think, in effect, that we have to change the rules. So let me give you an illustration of that kind of statute, which is very much in the news today. It certainly has to do with the minimum wage laws. What should it be? How high should it be? Or, in other days, there are maximum hour laws. And both of these today are extensively regulated by a statute which is called the Fair Labor Standards Act, which was passed in 1938 at the height of the New Deal by a very democratic Congress, which I'm happy to say was voted out of office several months after these statutes were passed. But the statutes linger on even after the legislatures who voted for them are removed from office. Now, what do these statutes say? They said, we do not trust people to represent themselves in voluntary transactions. We do not accept the model, cooperation, yes, because we don't think that these transactions are in fact transactions for mutual gains as between the parties. And so what they want to say is we have to basically change the fundamental distribution of rights that exists as between these two parties. And then you ask them why are they willing to do so? And the most common reason, the only one I'll talk about now, is that the inequality of bargaining power means that the firm is so strong relative to the individual that the wages will leave the worker worse off than they were if they had no contract at all under one version, or worse off than they would be if they could unionize and organize on the other. Two very different types of position. And so the question you have to ask is, what do you think about these statutes? Well, these statutes are not designed to expand the set of transactions that people can make voluntarily by giving secure signposts as between the two parties and as against the rest of the world. These statutes are designed to limit the contract choice in order to protect one side against the advantage taking of the other. If you start to think about this as a good common lawyer, you don't like these statutes. Now, why is that? Well, you look at individuals and you say, are they being subject to misrepresentation and deceit, or somebody holding a gun to their head? And with respect to wage contracts, when people come back day after day, if the deal isn't what they wanted, they won't return. So these contracts tend, by and large, be things that people regard as in their own judgment. So is it paternalism or worse for the state to come back and to tell you, you know something, you're really worse off under this contract. even though you don't know it, so we're going to stop you from entering into it. And it's not just these kinds of contracts. There are contracts, for example, where you'd like to take medical services, take a drug, which is highly risky. Well, somebody mentioned Tom Griffin, right? Friend of mine, he wrote a very famous opinion called Abigail's Alliance, in which he upheld, accurately, I'm sorry to say, under current law, that the FDA could prevent you from taking a drug that you and your doctors think to be necessary for the preservation of your health because they know better than you do. That is, we accept the paternalism. And I think most people who actually know something about the field don't think the guys at the FDA know more than the personal doctors you get from Johns Hopkins University, but that's the way the world runs. So these are two very different kinds of arrangements from the ones that I've talked about before. Now, you now start to think about this as a constitutional matter. Is the legislature all-powerful in the way in which it starts to put together the way in which it governs these arrangements? And at some level you say, this cannot be, because the whole definition of constitutionalism is that you put into place certain kinds of major constraints on what political bodies can do, because frankly, my dear, we don't always trust them to act for the public interest. Often they can be taken over, as our friend James Madison said, and if you've never read it, run out to your nearest iPad and read it, Federalist 10, that factions can take over government and make sure that the legislation makes one group, either a majority or minority, win, while the other groups tend to lose. Whereas the statutes that I was talking about, with the statute of frauds and so forth, are win-win all around. Everybody's better off from secure transactions. Everybody is not better off with a higher minimum wage law or with a direct prohibition on your ability to acquire drugs. Well, now, how do you attack this constitutionally? Well, there are two major kinds of provisions in the Constitution, and you have to figure out how you read them presumptively. And they are the structural provisions, what can the federal government legislate on, and then there are provisions about individual rights. What is it that people cannot be told they can be forced to give up? That is, it's their right, even against a majority of everybody but themselves. Answering these two questions is a matter of profound political difficulty, because we all believe in individual rights, and we all believe in majority will, and it turns out you can't have both at the same time. You have to be able to figure out the domain in which the rights dominate the common will, and the other way around. And if somebody comes to you and they say, individual rights always prevail, you're dealing with a snake oil salesman. And if it turns out somebody says the collective good is always correct, you're dealing with another snake oil salesman, maybe selling a different brand of snake oil, but it's the same problem. So how do we get to a constitution? Well, there's this nasty little problem about the Constitution, which is it contains words. This is a serious issue, because you then have to figure out what these words mean. And I will give you, before you get to law school, if that's where you're going, the following little piece of advice. When you're talking amongst yourself and there are no stakes on the table, you know what all these words mean all the time. But the moment you start making a dispute in which money or liberty is at stake, ambiguity in the minds of most people will start to rule the waves. So lawyers say, my God, we have no idea what you mean by the phrase proximate cause. I hope most of you in your lives have not heard of it, at least the non-lawyers. But on the other hand, you all understand what's a punch in the nose. And being able to figure out what the relationship between those two things are is extremely important. If, in fact, you believe in the kind of advanced linguistic skepticism that every word under pressure dissolves into a senseless agglomeration of sounds and grunts, then you've given up on constitutional law. Either you believe that phrases can have discernible and consistent meanings, as they do in ordinary discourse, presumptively, or what you do is you believe that every set of rules becomes the arbitrary commands of a sovereign who's accountable to nobody because there's no way in which to bind. And there has never been a period in our history where people have consistently taken the skeptical view. People will often change their views as to what is or is not a protected right. But if you're a liberal Supreme Court justice and the matter is gay marriage, this is an inalienable right given to you from the beginning of time. If you're a conservative judge and you believe in freedom of contract and economic affairs, that is also a fundamental right. So the two guys switch over one way or another. The question is, how do we resolve it? Well, there's a famous article written many, many years ago by a great philosopher named J.L. Austin. And the title of this work is, "What is the Meaning of a Word?" And that seems very easy. And then Austin was a great philosopher because he says, I can't answer that question. It's not a question of being more general, like the word building is more general than the word house. It's you haven't given me a word to tell you the meaning of. If you ask me the question, what is the meaning of the word chair? I can tell you it's a seat with a back, and I don't have to commit myself to whether it has 4 legs or 5, or even 3. Take off the back, it's a stool. I could define both of those words. And then you have those funny cases where you get that little concave curve at the rear of the thing, and you don't know whether it's a fancy dance stool or a really jazzy chair. And you know what? We could spend our lives debating about it, and if something turned on it, called the chair tax, we would be genuinely perplexed as to how it would come out. But most of these things fall relatively straightforward into one class. So in order to figure out what the Constitution means, you have to figure out what its words mean. And I have here Epstein's law. You get a dumb Constitution and you're an honest judge, you come up with a lot of dumb results. His job is not to purify a stupid document. His job is to explicate and to explain it. And if you have a good Constitution, you don't want to mess it up by changing its meaning on. So, if your Constitution says there's no such thing as private property because everything is owned by the state, you're in a Marxist universe, you better expect some very bad results, as you can't keep me and thee separated. But our Constitution doesn't say that. It says, nor shall private property be taken, that is by originally the Congress, for public use without just compensation. So we protect private property, which somebody else abolishes. And then, if you look at other provisions in the Constitution, they also are short in terms of words used and profoundly difficult in terms of their meaning. So if you take part of the First Amendment, it protects freedom of speech. You think you know what speech is, but nobody today uses the word speech. They always jazz it up a bit to cover expression. And why is that? Because they don't want dancing or art to be out from the thing simply because somebody isn't moving his mouth or writing. And indeed, could you imagine a genius constitutional lawyer saying, well, we protect the freedom of the speech, but that's only oral stuff. So if you write something down, you have no constitutional protection at all unless you're a member of the press. You're not impressed, I hope? That's because these words are complicated. That's why you have to always worry about a government which is about to do you in by reading something excessively narrowly in order to get around it. So I now call this the Noah principle in honor of my now 6-year-old grandson, who was completely aware of this when he was 4 years old. And so I go to Noah, and he's acting particularly badly. And I said, Noah, you're not allowed to hit anybody. And he looks at me, and he takes it all in. And 2 seconds later, with a sly grin on his face, he kicks me. You didn't say anything about that, Grandpa, right? So it's not covered by the prohibition. Now, the interesting thing is that the smile knew that he understood the linguistic conventions associated with the word hit, and he knew he was breaking the rules, but he found that there was a certain psychic gain to taking after his law professor grandfather under these circumstances. And you all know those games as well because you've played them as well in your own life. And so what happens is you have these terms, and now all of a sudden you have to figure out what they mean. And if you say that the legislature can give them any meaning that they want, it ceases to be a constitution. Well, where do these terms get their meaning anyhow? Well, remember we talked about those early judges and those early Roman jurists who started to talk about these things? What they did is they gave you a definition of what was private property. And they would talk about a thing, and they would give you its attributes for ownership. So if you're talking about land, there was the famous ad coelum maxim. You don't know what that means. It means if you own the surface of the land, you own to the top of the heavens and to the depths of the earth. Wasn't Roman in origin, but it has a physical spatial situation. On the other hand, if I take my iPhone out of my pocket, nobody says by virtue of the fact that I own this iPhone, I own the world to the top and down to the bottom, right? That goes to the guy who owns the land. So the rules on ownership, a little bit different for chattels from what they are from real property. Then you have to figure out, well, what can you do with this land? And so we say, what property is, it's the right to exclude others. That's not a bad start. Doesn't explain water, different problem. But it certainly helps explain land. My home is my castle, you can't come in. But if the only thing you think land embodies is the right to exclude, then you can keep other people off. Not so clear you can enter the land yourself at all. So now you have to imagine a system in which the right to exclude is the sole dimension of property, but going on the property can be prohibited by the state. Just at willy-nilly. And then you say to yourself, well, how valuable is this property going to be if nobody can use it? Unless the state and I agree as to how it ought to be done. They can't get in, and I can't get in either. So most people say, no, you could take possession of the land. Well, it's great to take possession of the land, but now you're allowed to sit on the land, but you're not allowed to use it. This is not going to be very valuable. You can't farm it, you can't build on it. So then people say, hey, you got to tack on use rights and development rights. But then we started to talk about our friend cooperation. Well, got to be able to cooperate. Got to be able to borrow money to build a house. Got to be able to pay somebody wages to do something on the house. Got to be able to rent it out to somebody for a particular purpose. So all of a sudden, this institution of private property takes on its common law form, and it turns out to be a surprisingly robust arrangement in terms of the protections that it starts to give to individuals. And if you're one of these guys who don't like the system of private property and like the administrative state, this becomes a serious obstacle to what you want to do. So essentially what happens is, whether you're talking about this or freedom of speech or the free exercise of religion, all of a sudden you see how strange the pyramid is. The common law rules at the bottom are displaced by legislation, and then as you start moving up a level, it turns out that these rules, in turn, are now going to be displaced by constitutional norms that reinstantiate the common law rules, subject to those rules which are fine, which stabilize common law relationships. So when a common lawyer looks at the Constitution, what the fellow says is, we look at the Constitution just the way our friend Gaius did when he wrote about natural law and statutes in 160 AD. He said, look, these basic relationships are so powerful that you can't let the state arbitrarily define them. It will not do to have a government come along and says, we think that private property means that if you own a house, every Thursday you're allowed to enter it for 15 minutes. That's our new definition of private property. Can't do that. You got to worry about possession, you got to worry about use, got to worry about sale, and then somebody says, well, what about access? And it turns out you develop a huge body of law as to whether or not when the government builds and changes and alters its streets, can it make it so difficult for you to enter your land that that's a taking, even though they don't come on? And then they got to compensate you. So you have all of these terms, one after another, they start to build up. Give you another illustration. What's the free exercise of religion? Well, this is a very hot topic today. We have the Religious Freedom Restoration Act, which everybody loved in the year 1993, and which the liberals have repudiated in 2015, right? And it's supposed to protect the free exercise of religion. And if you're somebody who doesn't like religion, free exercise means you have the right to worship God in whatever way you see fit. But it doesn't apply to the way in which you lead other features of your life. So, for example, does it tell you when you can pray? Yes, it could tell you can't do that. Does it tell you how you can organize your workshop and whom you can do business with, or whether or not you can be forced when you go into government service to eat foods that are against your religious belief? That's not worship, that's just eating, not protected. To somebody who looks at it in its, quote, natural meaning, it seems to have the other meaning. Anything that I do, which is part of my religion, is part of its exercise. It's not just prayer and it's not just thought. And so then I come up to you and say, okay, part of my religion involves child sacrifice, and preferably children of other religions. And then somebody says, well, that's the free exercise of religion. And then you have to remember that dirty little word. What word do you have to remember? Presumptively, right? Well, what's the presumption? The presumption that we have under the classical liberal constitution is that you're entitled to essentially do whatever you want with your own property, so long as you do not use or threaten force against other individuals. That was a basic norm. That's the norm that kept society together. That's the norm which essentially says that you cannot decide to run jihad or crusades under the banner of religion if you wish to take innocent life. You ask yourself, do you really want to get rid of that particular exception? Well, the answer is no. Can you really say that killing somebody in accordance with your religious command isn't the free exercise of religion? You can't say that either. And so this starts to lead to how constitutional words work. Essentially what happens is you got the basic word, like you can't take and you can't hit, and you have to remember my nephew's law. We don't allow you to have cheap circumvention of it. So in Roman days and today, somebody says, I didn't hit you, I just set a trap, I hid it and concealed it, you walked into it, you killed yourself because you took the last step. And everybody's looking at me and I see a few enormous giggles in the crowd. That's because this is not funny, this is tragic. That anybody would want to make that argument, because we're always worried about how people will try to circumvent commands that are designed to protect other individuals, and your interpretation has to cover that. We've seen it with force, and we've also seen it a moment ago when we were starting to talk about expression as being the term that we use instead of the narrow term speech. And we do this not because the text commands it, but because if you go back to the natural law theories and the common law theories that undermine it, that's the way they worked as well. Every single rule that I'm talking about now was fully articulated and fully understood in ancient Rome. That is, we tend to think of these guys as naive, they don't know very much, but if you go back as I do and you teach Roman law text by text, page by page, all of a sudden it becomes clear that these jokers understood exactly what they were doing. So now this common law constitution gets more complicated because we have our first problem of figuring out how we read the coverage provisions. We can't be too literal about them because substitution or circumvention becomes too easy. And the entire tax code is designed to prevent people from circumventing their duties to pay taxes. You got to worry about this with government. And then the other part of constitutional law that you also have to worry about is that part of the Constitution that is written in invisible ink. That does not seem very encouraging, right? So let me tell you just how indelible the invisible ink turns out to be. If you go back and you read every 19th and early 20th century treatise, what you will find is that their title contains somewhere in it the words police power. Then what you do is you pick up your Constitution. You don't have to read it anymore. You just run a search function through there with the word police, and you come up empty. Not there. No police power whatsoever. So then you have to ask yourself the question, why is it that a word or a phrase that is not in the Constitution turns out to be the central phrase of analysis of the Constitution, long before we get to modern socialism and modern gimmickry? Well, it's because of the illustrations that I gave you, which is if you were a private party and you wanted to essentially develop your land, and the only way you could do it was to put an exhaust pipe into your neighbor's living room emitting carbon monoxide, somebody would say development is fine, but the creation of a nuisance is not. And so when the common law starts to develop into the public law, what we do is we follow the same propositions. Whatever is bad conduct between two private parties is bad conduct which the state can protect against because the private remedies don't work. So if you remembered when we started to talk about why it is that we had writing requirements for contracts, it was because otherwise they didn't work. If you have somebody who's polluting an entire neighborhood, it turns out private rights of action don't work. You don't believe me? Look at Flint and ask yourself how a bunch of lawsuits are going to work, as opposed to a decent system of public government, which means that neither the state nor private parties could put lead into drinking water, given the fact of its horrific effects on mental development, muscular coordination, and every else you think about. So what you want to do is to have a state which can prevent these kinds of things, and when they talk about the police power as a way to protect health and safety, that's essentially the payoff from the proposition that we do not allow people to do whatever they want when it comes to government, because we do not allow people to do whatever they want when it comes to each other. And the correlative is, if the people can't do it to each other, then by all means, please don't say that the state can do it to us. And why is this important? If you look at the two most important recent environmental disasters, both of them are government-made. The folks from the EPA managed to blow up a system of caves and create an amount of pollution in the Animas River in Colorado worse than anything that has ever been done, for which the EPA head, Gina McCarthy, said, "I'm sorry." And all is well, right? You look at Flint, what you do is you have a classic instrument of, quote, cooperative federalism, where the city says it's the state, and the state says it's the national government, and this agency says it's that agency, and the whole thing degenerates because nobody was able to do it right. And so what you have to do is to understand that putting a government together, its first job is to prevent these miserable nuisances from taking place. And the second is to make sure that they don't become the very aggressor in this area, that they, by engaging in conduct of the sort that you would never tolerate in private individuals. So now you see why constitutional law turns out to be an extremely difficult subject. You got all of these things about how it is you have implied limitations on the individual rights. You have to put the state in charge of their control. And then you have to worry about the fact that the state who's in charge of the system may make it worse because the individuals who govern may not be accountable for the wrongs that they start to commit. So what does this then start to tell you about how the business goes? It says, in effect, when you're dealing with errors of commission and omission, you never reach the sweet spot in which you're sure that you got the right mix of private rights of action for nuisance, public controls over nuisance, public controls over the public officials who administer the judicial system or the regulatory state. It's always in flux. So what happens is you now see that you switch the way in which you think about government. In the beginning, it was high theory. In the beginning, it was normative inquiry. Now, it's a question of remedy and structure, in which errors in every direction are conceivable. You try to plug one hole up, another one's created. An old friend of mine said many, many years ago when I was first starting to teach tort law, he said, you think of the government and the society as a ship, and you think of all the planks which are fixed, robust, and protected, and the boat is going swimmingly over the water. But you have to understand it's going in very choppy seas and with very dangerous folks around it. And the question you have to ask about your institutions is how many blows below the waterline can it take without filling up so much that it sinks? So the argument essentially about statecraft is you know you're always going to make errors, no matter which way you move. But you also know that some errors are bigger than other errors, and then you have to know which errors are the biggest of all. So when I started law, and I'll end on this point so we can have some questions, essentially I was what they call a concepts man. I tried to figure out what the meaning of possession was, the meaning of proximate cause was, the meaning of consideration, that's what's a bargain, what's not, the meaning of possession, all these wonderful words, and you can make a lot of progress. But when you switch from entitlements to institutions, you have to develop a very different frame of mind. Now you're worried about design, You're worried about people gaming systems. You're worried about observable behaviors, the simplicity of remedies, whether or not it's better to regulate too little or too much, whether it's regulated at this level or at that level. And that's the work of a lifetime. Why is it that I'm so unhappy today about much constitutional law? It's because I think the people who do this get the wrong major premise. What they do is they either assume that courts know everything or that the legislature kind of knows everything. But there's no deus ex machina. Ultimately, in our system, the judges have to have the last word, and that means they have to develop reasonably coherent theories as to when they ought to put the kibosh on somebody and when not. And if they realize that whenever the government starts to allow force that ought to be prevented, that's a bad thing, and whenever it turns out that they negate cooperation, the latter, they have to have a very strong reason for overriding it, and the same thing with the initial presumption. And what's characteristic of the modern state is that the willingness to override cooperation, yes, and harm, no, turns out to be all too willing, and it's in that particular frame of mind that we see the serious challenge today in the progressive era of the classical liberal constitution that at painful length I defend in the book that's over there. I hope that freshmen could read it and that adults could read it. I hope the book is written clearly enough, but I hope too, whether you read the book or not, that the basic measure of intellectual simplicity on entitlements and intellectual complexity on institutions and remedies is one that you take with you through your further studies.